Streaming now, and we'll go live in just a moment here. All right, here we go. Thank you, everyone.
Good morning, everybody. I'm Michelle Espinoza, Chair of the Real Estate Commission. Today is Tuesday, August 6th, 2024. It is now 9:03 a.m. Could you please take roll call, Director Waters?
Michelle Espinoza.
Here.
Renee Lind.
Here.
Autumn Rubal.
Here.
Erica Doyle.
Here.
You have a quorum.
Great, thank you. I'm going to turn over briefly to David Donnelly to take a quick poll.
Good morning, commissioners and the public. If you, I'll be placing a poll on the on your screens for anyone that is interested in seeking continuing education credit, provided that this meeting lasts the required 2 hours. So if you could please complete that poll if you are seeking continuing education credit, I would sincerely appreciate it. We'll leave that poll open for a little while here, and then with that, commissioners, I will pass the buck back to you. Thank you very much.
Great, thank you. The Colorado Real Estate Commission, the Commission has the authority to promulgate real estate forms for current use by real estate brokers pursuant to Section 12-10-403 CRS. These forms are referred to as Commission-approved forms. The purpose of this hearing is to hear oral testimony and accept written submissions relating to the following Commission-approved forms: agreement to amend, extend contract, counterproposal, residential addendum to contract to buy and sell real estate. In addition to my fellow commissioners, here with me today are Director Waters, Senior Advisor Phipps, Director Liaison Doreen Archuleta from the Division of Real Estate, and Gina Simonson from the Attorney General's Office. The public record will consist of all testimony and any written information submitted within the allowable timeframe. In addition to the public comments today, the Commission will review any written materials to make the final decision on the proposed new and modified forms. The public record will close at the end of this hearing. Let's now have Director Waters explain the proposed modified forms.
So, commissioners, the first form is the agreement to amend, extend contract. The change on this form is in Section 2, Item 37 of the grid. The word terminate was added to indicate environmental inspection termination deadline. On the counter proposal in Section 2, Item 37 of the grid, the word terminate was added to indicate environmental inspection termination deadline. And then with the residential addendum to the contract to buy and sell, the home warranty advisory was moved up in the form to Section 2.5.4. That is the extent of the form's changes.
Great, thank you. Any comments or questions from my fellow commissioners?
I assume we're also going to change the dates on all these.
Yes, we will update those.
Okay.
And are those effective 8/15 or are those effective on January 1st?
They will be effective 8/15.
Okay. Any other questions from the commissioners?
No.
All right, at this time, we will start with the testimony phase of the hearing. Each speaker will have 3 minutes to speak. Please speak clearly and slowly for the recording. Please state your full name and identify the name of the organization that you are representing, if applicable. Finally, please limit your testimony to only the proposed new and modified forms and do not duplicate testimony. Should the commission or any of its representatives have a question regarding your testimony, we will ask when you have finished your testimony. If you desire to provide testimony, please raise your virtual hand so division staff know who to call on. David, do you see any hands?
Commissioners, no, I do not see any raised hands at this time.
All right. Thank you. That will end the testimony portion of the hearing. We will now consider the proposed new and modified forms. Do I have a motion regarding the proposed forms?
I motion we approve the changes to the 3 modified forms.
Do I have a
Second.
Thank you. It's moved and seconded to adopt these changes. Any discussion? All right, all those in favor?
Aye.
Any opposed? Motion passes for the proposed new and modified forms. This concludes this hearing. Thank you. We are now going to move on to our regular meeting. Marcia, do we need to take roll call again?
We can do that. Michelle Espinoza,
Here.
Renee Lind,
Here.
Autumn Rubal,
Here.
Erica Doyle.
Here.
You have a quorum.
Thank you. All right, we need a motion to approve the June 4th, 2024 Real Estate Commission meeting minutes.
I motion we approve the June 4th meeting minutes.
Do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes. We need a motion to approve the June 25th, 2024 Real Estate Commission non-rulemaking meeting minutes.
Motion to approve the meeting minutes from June 25th.
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes. Next, we have public presentation of issues not on today's meeting agenda.
Members of the public, once again, if you would like to select the raise hand icon at the lower part of your Zoom screen, we will be able to unmute you. Commissioners, seeing none, I can. Yes, no one at this time.
All right, thank you so much. Next order of business is policy matters. Director Waters.
So commissioners, you need to elect a vice chair so that you have someone to take the reins if Chairperson Espinoza is not available.
Anybody volunteers tribute?
Sure.
All right, I nominate Renee as vice chair.
I would second that.
Thank you. First and a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes for Renee. Thank you, Renee. Thank you
Yep.
for volunteering as tribute.
Thank you, Renee.
Yeah.
Is there anything that you would like placed on your next meeting agenda?
I don't have anything.
No.
Okay.
All right. Looks like we are on to complaint investigations and audits.
Morning, commissioners.
Good morning.
Your first agenda item is investigative matter A. This is complaint number 2023-829. On May 3rd, 2023, an anonymous complaint was filed against the respondent stating that the respondent violated his fiduciary duties as a buyer's agent to a Spanish-speaking senior. The complaint alleged the respondent failed to inform the buyer of the costs associated with the hard money loan. The investigation noted the respondent's primary language is English, and the respondent enlisted his father to assist with translating and communicating between the buyer and the respondent. The buyer was not able to secure traditional financing and alleges she does not understand the type of loan she was given to purchase the property. The respondent states the buyer was properly explained her options once she was denied a conventional loan and the buyer chose to proceed with obtaining a higher costing loan through a hard money lender. The buyer then refinanced a few months after closing with the help of the respondent's father as a co-signer. The respondent appears to be unaware his father helped the buyer in refinancing. The respondent's father now wants the buyer to either sell the property or refinance again in order to remove him from the mortgage. The buyer has not refinanced and does not want to sell the property. The respondent's father is still in the mortgage. The buyer states that the respondent and his father have made no further attempts to request that she sell or refinance the property since the complaint was filed. Possible violations include 12-10-2171M, violation of any commission rule, 12-10-2171Q, unworthy incompetent practice, 12-10-4051B, single agent engaged by a buyer failing to exercise reasonable skill and care, Rule 6.2, competency. Recommended disciplinary action includes a final agency order, a fine of $5,000, public censure, and coursework in ethics. And myself and Investigator Rivera are here to answer any questions you may have.
Great, thank you. Do we have any comments or questions on this case? All right, hearing none, may I get a motion?
I motion to accept staff recommendation.
We have a second?
I'll
I would
second.
I
Sorry, Mika.
think I heard Autumn first, thank you. All right, we have a first and a second. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Alrighty, your next two, investigative matter B and investigative matter C, are the same respondent, have a kind of combined discipline on the two. Investigative matter B is complaint number 2023-155, and investigative matter C is complaint 2023-388. For investigative matter B, on January 26, 2023, the complainant filed complaint number 2023-155 against the respondent, stating that the respondent failed to provide owner statements and failed to remit January 2023 rent and return the security deposit upon termination of services. The investigation noted the respondent did remit missing funds to the complainant after the complaint was filed. The respondent failed to provide owner statements or a final accounting to the complainant. The respondent failed to provide 3-year reconciliation reports, monthly journals, or ledgers for accounts holding funds of others, including the security deposit account. The respondent failed to provide management fee reports to detail management fees due per month, and the accounts used by the respondent regularly appear to commingle trust funds with broker funds. It appears the respondent has shut down the business, and currently the respondent's real estate license is inactive due to an E&O insurance audit as of March 13, 2023. Possible violations include 12-10-2171H, failure to account for funds received, 12-10-2171I, converting, diverting, commingling funds, 12-10-2171M, violation of any commission rule, 12-10-2171Q, unworthy incompetent practice, Rule 5.2, money belonging to others must be deposited in trust or escrow, Rule 5.10, commingling prohibited, Rule 5.14, record keeping requirements, Rule 5.15, maintenance and production of reports to beneficiaries, Rule 5.21, production of documents and records. Recommended disciplinary action includes final agency order, public censure, revocation, $40,000 fine. And like I mentioned, this is combined with the following investigative matter. And again, Investigator Rivera and myself are here to answer any questions you may have.
Great, thank you. Commissioners, any questions?
Should we go ahead and discuss the other one since the
Yeah, I could read the
it's tied
narrative
together.
if that helps. Yeah. So investigative matter C, this is complaint number 2023-388, same respondent. On March 3rd, 2023, the complainant filed complaint number 2023-388 against the respondent, stating that the respondent failed to provide owner statements, remit rents in 2022, and return the security deposit upon termination of services. The investigation noted the respondent did remit the missing security deposit funds, but has failed to provide accounting of funds to the complainant. The complainant alleges the respondent owes $6,000 in rents. The respondent failed to provide owner statements, invoices, and a final accounting to the complainant. The respondent failed to provide 3 reconciliation reports, monthly journals, and ledgers for accounts holding funds of others, including a security deposit account. The respondent failed to provide management fee reports to detail management fees due per month. The accounts used by the respondent regularly appear to commingle trust funds with broker funds, and it appears the respondent has shut down the business, and currently the respondent's real estate license is inactive due to an errors and omissions insurance audit as of March 13, 2023. Possible violations are the same: 12-10-2171H, failure to account for funds received; 12-10-2171I, converting, diverting, commingling funds; 12-10-2171M, violation of any commission rule; 12-10-2171Q, unworthy incompetent practice; and rules 5.2, money belonging to others must be deposited in trust or escrow; rule 5.10, commingling prohibited; rule 5.14, record keeping requirements; rule 5.15, maintenance and production of reports to beneficiaries; and rule 5.21, production of documents and records.
Okay, so I have a question. It looks like on C that money is still owed, but it looks like on B that it was paid. Is that correct?
Correct.
So is this being referred over to a different office for monetary?
Could do that as well.
Since there's still money being, yeah. So I guess, do we need to add that on the bottom?
I'm typing that in as we speak. If you would like
Okay.
a referral to criminal law enforcement.
Yes. So I would say with that addition, I am fine with staff recommendation. Anybody else have anything?
I agree with that.
I'm good. So Renee, you want to make a motion with that change?
Sure. I move to accept staff recommendation on B and C combined with the addition of the referral to criminal investigation.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Commissioners, we pulled item D. Item E is an audit performed by Betsy Meredith. She's here to answer any questions that you have. This audit, it's X 2024-50. This audit was required as part of a signed stipulation, which required that the broker demonstrate compliance with the 3-way reconciliation, required disclosures, and property management forms. The respondents' initial responses indicated that none of these 3 areas were in compliance, as the reconciliation was missing the required journal, disclosures had still not been provided to tenants, and the property management forms may not comply with the provisions outlined in Rule 7.1 forms. Though the broker was provided clear direction as to what was required, both within the stipulation and within this audit, the broker was unable to provide evidence that the tenants had been provided disclosure, that her forms comply, or an explanation as to why the journal was not provided with reconciliations. After reviewing the separately submitted accounting documents, it does appear that the broker is properly accounting for money belonging to others, but the other 2 required aspects of her stipulation remain out of compliance. Possible violations are 12-10-2171Q, unworthiness and incompetency; 12-10-2171M, violation of any commission rule or part 4; Rule 6.5, brokerage relationship disclosures in writing; 7.1, standard forms; and 6.20, transaction file requirements. Recommendation is for a final agency order, public censure coursework, including best practices for safety and accountability in real estate and contracts, a fine of $4,500, and then also the requirement that she provide evidence of full compliance within 90 days of signing this stipulation. And Betsy's here to answer any questions that you may have.
Good morning, Commissioners.
Good morning.
So the radon disclosure was incorrect as well. Would that be covered under the best practices, safety and accountability, that course? Or
I
is
believe so.
Okay.
Any other questions? Hearing none, may I get a motion?
I motion that we accept staff recommendation on E.
Second.
Thank you, Erica. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Commissioners, matter F is case number 2023-2399. Rob Walker is the investigator for this complaint. The complainant alleges that the respondent orchestrated a scheme to defraud a commission advancement company out of over $4,000. The seller of the property alleges that the respondent represented that she would list the property for sale at a reduced commission, along with using her broker's commission to reimburse the seller for back rent owed. At closing, the seller alleges that she was charged a higher commission rate and was not reimbursed for the back rent. Possible violations include 12-10-217-1B, making a false promise to influence, 12-10-217-1C, deliberate misrepresentation, false promise, 12-10-217-1M, violation of any commission rule or this part 4, 12-10-217-1W, dishonest dealing, 12-10-4072B, failure to exercise reasonable skill and care as a transaction broker, and Rule 6.25, must submit a written response to a complaint. The recommended discipline is a final agency order, public censure, revocation, and a fine of $12,500. And Rob is here to answer any questions that you may have.
Great, thank you.
So should this also be a referral for criminal investigation, or is that something we leave up to the company?
The company's already filed a criminal complaint.
Okay. Okay.
Any other questions? Hearing none, may I get a motion?
My motion to accept staff recommendation.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Good morning, Commissioners.
Morning.
Good morning.
The next is matter G, complaint number 2023-1695. The complainant alleges that the transaction documents of the respondent, who was the listing agent, were fraught with errors such as incorrect property descriptions, inaccurate terms and conditions, and missing clauses that were essential for a legally sound agreement. Possible violations include 12-10-217-1Q. Disciplinary recommendations are diversion, a fine of $1,000, and Investigator Gabarty can answer any questions that you might have.
So I actually thought the fine on this one should be increased to the 2,500 instead of just the 1,000. This was a real mess.
I don't have a problem with that. I was trying to see, how long has this broker had their license?
Let me check.
Sorry, I thought I had it notated, but I was.
Should be on their report on page 1. Let me look.
She was, according to e-license, she was first issued her license on August the 6th, 2013.
Oh, wow. Okay. Yeah. Yeah, I agree with you, Renee.
Okay. So I'll make a motion to accept staff recommendation with the increase of a fine to 2,500.
We have a second?
I'll second.
Thank you, Autumn. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter F is complaint number 2024-709. On January 6th of 2024, the respondent pled guilty to 1 count, felony assault in the 2nd degree, strangulation. The court agreed to a 2-year deferred judgment and sentence that included supervised probation for 2 years, domestic violence evaluation and counseling, and court costs and fees in the amount of $1,646.50, which has been paid in full. Possible violations include 12-10-217-1M, 12-10-217-1N, 1210 to 171P, and Rule 6.23. Disciplinary recommendations are diversion, a fine of $500, and probation to run concurrent with the deferred sentence. And Investigator Gabarty can answer any questions.
Just to clarify, this is matter H, correct?
Matter H.
Yeah, okay. So I move to accept staff recommendation.
We have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Matter I is complaint number 2024-860. On April 30th of 2024, the respondent pled guilty to a charge of felony burglary 2 of dwelling. He was then sentenced with a deferred sentence of 18 months, various evaluations and treatments, a protection order, and court costs and fees in the amount of $1,293.50, and that has been paid in full. Possible violations include 1210 to 171N, and disciplinary recommendations are diversion, a fine of $250, and coursework in tenant rights. And Investigator Gabarty can answer any questions.
And just to clarify, this one is $250 instead of $500 because CBI reported it to us before the 30 days. Is that correct?
That's right.
Okay. All right. Then I move to accept staff recommendation.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Matter K is complaint number 2024-507. On March 7th of 2024, the respondent was convicted of theft between $100,000 and $1 million.
We
Class
skipped
3.
J.
Yeah.
Sorry?
We
Sorry,
skipped
we
J.
skipped J.
Oh, sorry. Let's see. Okay, matter J is complaint number 2023-1958. The buyer, who is the complainant, alleged that the buyer's agent, the respondent, did not protect her $10,000 in earnest money. Possible violations include 1210 to 171Q, 1210-405-1. Disciplinary recommendations include final agency order, public censure, fine of $2,500, coursework in brokerage relationships, coursework in contracts, and a high-level supervision for 2 years. And Investigator Peters can answer any questions.
I thought part of this was the buyer's fault, not just the agent's fault personally. So I just wanted to bring up the public censure part. I don't know if there's discussion on that, but I think it's not all one-sided on this case, unless other people disagree.
Well, definitely communication, but I mean, you would always submit an amend extend on that. You would not have submitted a second contract
Right.
under any circumstances that I could see.
Part of what bothered me about it was things that were said about not saying that they would, do something, and then the text messages said something totally different. So I felt like there was some dishonesty even to the investigator about what had happened when there was proof within the text that the complainant was actually telling the truth.
Like as far as the earnest money.
Mm-hmm.
Okay.
Now I know it's not their responsibility
Right.
to do that. However, the respondent took on that responsibility by saying that they would. So
Okay.
But the fact that they were dishonest about to the investigator about it instead of owning it.
Okay,
Um,
all right, I just wanted to have discussion, so, all right, I agree.
And I'm not saying no to the public center. I'm just letting you know what one of my
Yeah,
issues were. So
I just thought it wasn't all one-sided. That was the only
Right.
thing I was trying to get at.
Right.
I agree. I'm not locked in on public censure necessarily.
Yeah. I think they've had their license for 6 years. No other discipline that I can see. Correct me if I'm wrong. That was a rough time. COVID was rough. So I'm okay with getting rid of public censure. Because it's in the final agency order anyway.
So Erica, are you okay with that?
I'm fine with that. Yes.
Autumn?
Yeah, I think that's reasonable.
Okay, so,
Commissioners, before you vote, can I just add one thing? We need to add a violation of 1210-217-1M, which brings in that part 5 violation. So we would just add that additional violation.
what's it bringing in, Penny?
Whenever there's 1210-405, you need that 1M violation. It brings in another, either a rule or part 4 of the statute. So we would just add a violation of 1210-217-1M.
Okay,
It doesn't add additional fines or anything. It just brings in that 405 violation.
okay.
We just need it for the record, is what you're saying, Penny.
Yeah, it's the disciplinary authority is under that
Okay.
217. So we just need to bring in that 405.
Okay, so I move that we accept staff recommendation of J with the addition of 12-217-1M.
And
Remove-
remove public censure.
And sorry, yes, right, Erica, thanks. And we'll take out the public censure.
All right. Do we have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes.
Okay, now it's matter K, complaint number 2024-507. On March 7th of 2024, the respondent was convicted of theft between $100,000 and $1 million, a class 3 felony, and computer crime scheme DEF, a class 3 felony. The respondent was ordered to pay $4,191.50 in court costs and fees, which have not been paid. A restitution hearing is scheduled for July 15th of 2024. The respondent was also ordered to complete 6 years of supervised probation, which is ongoing. Possible violations include 1210-217-1N, and disciplinary recommendations are a final agency order, public censure, revocation, and a fine of $2,500. And Investigator Geske can answer any questions.
Don't we need to add that probation is concurrent with they've got 6 years? Don't we need to add that on here?
We're doing revocation.
Oh, sorry.
Any other questions?
No.
All right. Can I get a motion?
Motion to accept staff recommendation.
Right, we have a- Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
Matter L is complaint number 2024-554. The complainant, who is a potential tenant of the property, alleged that the respondent inappropriately retained the security deposit when it was decided not to rent the property. Possible violations include 1210-217-1Q, 1210-217-1H, and 1210-217-1I. Disciplinary recommendations are a final agency order, a fine of $5,000, coursework and legal issues, coursework and contracts, and restitution in the amount of security deposit, which was $3,450. And Investigator Geske can answer any questions.
I know there was a lot of this, well, there was some things looked at on the application as to whether it constituted a contract as far as the security deposit being paid to hold the property. Is that, so did the investigator determine that it was not a contract and that's why the money is going back? Could you talk about that a little bit?
Well, yeah, it was a security deposit that they required to hold the property. It was considered by the respondent as a fee, and they stated that the fees are non-refundable.
Okay, so if it's a fee, I'm just trying to get at why it is being disallowed, because there are other people doing this, and I think we need to address this. So
I have to say, I have a thing, what am I missing? But I don't understand property management very much either. So I have some education on like where it's coming from. Is it because is there a law or a rule somewhere stating that because of how it's worded? Or I think we just need some clarification.
I don't think it's within our rules and statutes, but I don't believe that you can keep a security deposit if there's no contract. They were not under a contract. They hadn't signed a lease.
Michelle, and that was some of my questions to Michelle and Renee, possibly, that, you know, I have some of their verbiage was damage deposit or off-market holding fee. Those are some of the terms that were there, and those don't seem to be reflected in the definition of a rental application fee in the House bill that we were able to review, 19-1106. So I have a couple of problems here. It's hard to make something non-refundable when they're not actually signing a lease and they hadn't had an opportunity to review the lease yet. That being said, the landlord or owner is taking the property off the market for everybody else. So I can understand a fee to be able to remove that so that other people, you know, don't have access to it. So I would like to get some clarity on what is or is not allowed. But there's just it's just not clear as to where they were providing this money. The security deposit would have been hard and fast in a lease that it was a security deposit. They're calling this something entirely different, a holding fee for taking it off.
So because it's a holding fee, is that acceptable?
Right.
So that's my question.
To piggyback on Erica's statement, I just had a question, because if they didn't qualify her as a leasee, if her credit score wasn't up to snuff, I mean, she had to have her daughter on the application in order to qualify for the lease, which she said very clearly she didn't want that. So without her daughter, she wasn't approved anyway.
But they both applied, and because they both applied, that's how they were looked at, were viewed, and she paid the holding fee. And then after the holding fee, then she said she didn't want the daughter on. And at that time, she wouldn't have been approved. But because they applied together and were technically approved and then paid the holding fee, I guess that's why I'm questioning this holding fee, because they're not calling it a security deposit, they're calling it a holding fee. So, and there was some discussion in the case about whether you could do that, because was the application considered a contract because it didn't have a signature. It only had signature on behalf of the applicant. It didn't have signature on behalf of the company. So was that a contract, and could they charge the holding fee? So I guess I was looking for some discussion and the investigator, you know, some of the legal, some direction there.
I think it boils down to what they're calling it, because Colorado law does not allow for, they make sure that security deposits are refundable.
Right, but they're not calling a security deposit. So if they're calling it a holding fee,
but the dollar amount excuse me, the dollar amount was the same as what the security deposit would be. It wasn't just a, smaller fee amount. It was the exact amount as what the security deposit would be if that was in place at the time.
And is it converted? It's converted to the security deposit once they sign the lease, correct? It's a fee and for the holding, and then it's converted to the security deposit moving forward.
It's collected at the time of the application, and the lease was not prepared at the time.
But it wasn't collected
the
at
full
time of
amount was paid.
application. It was collected after the application was approved. So that's why I don't know. I think this is really kind of an important case because a lot of people are doing different things with money as far as holding properties. Because if it's a holding fee, it's a holding fee allowed? Because they're not calling, it's not a security deposit, it's a holding fee. So is that allowed or not?
That might be a question for one of the AGs.
Yeah, I was just turning on my video and camera. Do you want to table further discussion on this and add this to an executive session? I don't think we have an executive session link set up for this meeting, but it doesn't sound like we can't do that. We do? Okay. So maybe do you want to continue on with the agenda and we'll just table this and go into executive session at the end, or do you want to go into executive session now to discuss it? That's your choice.
Let's table it just so that if we have other issues, we can do it all at the same time.
That seems very reasonable. And we'll update our executive session script and send that out to Michelle, and we'll wait and see what happens for the rest of the meeting.
Right.
Great, thank you.
Yeah.
All right, so we will table matter L until the end of the meeting, if that's okay. We can move on to matter M.
Matter M is complaint number 2024-456. The investigation found that there were potential violations concerning brokerage, employee supervision, record retention, E&O insurance coverage, and office policy manual issues. Possible violations are 1210-217-1Q, 1210-217-1R, 1210-217-1M, rules 6.3, 6.4, and 6.20. Disciplinary recommendations are diversion, a fine of $2,500, a coursework in brokerage administration, and a downgrade of the license to an FA level for 2 years. And Investigator Geske can answer any questions.
All right, any questions on this one?
I think the fine on this one is low due to the sheer number of issues on this case. I would like to see the fines increased.
Okay, what are you looking at?
At least double. There are just so many problems here on whether it's paperwork, responsibility, et cetera, et cetera, et cetera.
Renee, I agree with you.
So what do you think as far as the fine, Autumn?
I agree that I think it's doubling. There were so many issues with this, and just going through the text messages and yeah.
So 5,000. Okay. Anyone else?
I'm good.
I did have one, and this is kind of, I mean, it has to do with it, but it's kind of on the side. I don't know what you do when you have an agreement to provide a home warranty. You provide it, and then that company, following you coming to terms on that, cancels that for you. I know you can call another company and try and get that resolved as well, but if they continue to terminate that based on their inspection, I do think that that particular portion of that somewhat out of your hands. So that was an issue for me. What do you do in that scenario? She had taken care of.
The part of the issue I thought was that the home warranty was basically obtained 2 months after closing. So I've never seen a closing like that where you're not obtaining the home warranty
At closing.
prior to closing. I've never seen this. I don't know, maybe someone else
And
has.
that's why I said it's kind of on the side, but that is a concern that can happen.
Yeah, so
Moving on, sorry.
All right, do we have a motion?
a motion to accept staff recommendation with increase in fine to $5,000.
All right, do we have a second?
I'll second.
Any further discussion? All those in favor?
Aye.
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 Any opposed? Motion passes.
And next is matter N. It's complaint number 2024-708. On January 8th of 2024, the respondent pled guilty to assault 2, strangulation, a class 4 felony. The respondent was ordered to pay $1,608.50 in court costs and fees, and $500 of that has been paid. The respondent was also ordered to complete 2 years of supervised probation, which is ongoing. Possible violations include 1210-217-1N, 1210-217-1P, 1210-217-1M, and Rule 6.23. Disciplinary recommendations are diversion, a fine of $500, and probation to run concurrent with the deferred sentence. And Investigator Geske can answer any questions.
Any questions?
Yep. I move to accept staff recommendation.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes.
All right, good morning. Matter O is complaint number 2024-706. On April 11th, 2024, the respondent pleaded guilty to burglary 2 of a dwelling, a class 3 felony. Respondent received 4 years probation on a deferred judgment and sentence. This offense and sentence resulted in the revocation of a previous deferred judgment and sentence for misdemeanor menacing, in which the respondent had originally received a 2-year probation sentence. The sentence for the burglary charge will run concurrent with the previous probation sentence for menacing. The respondent's previous criminal case went before the commission in 2023 and resulted in a signed stipulation and a probationary license. The possible violations are 1210-217-1N and 1210-217-1M. The final disciplinary recommendation is a final agency order, a fine of $2,500, probation that is concurrent with sentencing, and then also a direct referral to the Attorney General, as that is where the other case is. And Investigator Coates is here to answer any questions you may have.
Great, thank you. Any questions?
Nope.
All right, hearing none, may I get a motion?
I motion to accept staff recommendation.
Thank you. We have a second?
Second.
Yep. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Right, investigative matter P is complaint number 2024-707. On August 11th, 2023, the respondent was arrested in Summit County, Colorado. The respondent was suspected of threatening another man with a gun. On February 14th, 2024, the respondent pled guilty to 1 count of 18-3-206, felony menacing, and 1 count of 18-3-206, misdemeanor menacing. The respondent received a deferred sentence and a deferred judgment for 18 months. The respondent was ordered to serve community service, take a course in anger management, and was granted unsupervised probation. The conviction was not reported to the Colorado Real Estate Commission. As of the date of the report, the respondent had begun community service and approved enrollment in the required anger management course. All fines and fees have been paid. Possible violations are 1210-217-1N, 1210-217-1M, 1210-217-1P, and Rule 6.23. Disciplinary recommendation is diversion, a fine of $500, and probation that is concurrent with their criminal sentencing. Investigator Levy is here to answer any questions you may have.
Thank you. Any questions or comments? Hearing none, may I get a motion?
I motion to accept staff recommendation.
A second?
Second.
Any further discussion? All those in favor?
Aye.
Any opposed? Motion passes.
Matter Q is complaint number 2023-1996. The complainants filed a complaint against the respondent, who was the agent owner of the property they purchased. The complainants allege that the respondent failed to disclose all adverse material facts to them, including a structural and engineer's report. Possible violations are 1210-217-1Q, 1210-4043A, and 1210-217-1M. Disciplinary recommendations are a final agency order, public censure, a fine of $4,000, and coursework and ethics. And Investigator Peters can answer any questions that you might have.
Thank you. Any questions or comments on this one?
I would recommend increasing the fine from $4,000 to $5,000.
I would be okay with that.
Autumn, is that okay with you?
Yeah. Yes, it is.
All right. I move to accept staff recommendation with increase in fine to $5,000.
We have a second?
Second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. All right, since we are tabling matter L, we are now on to licensing matters.
Is it possible that we could go ahead and go into executive session now? Because I have another question relating to the licensing matters.
Okay, I am just waiting for my script from.
Yes, let me get what licensing matter that Commissioner Lynn wants to go into so we can put it on the script. Which one?
A and B.
A and B. Okay, I'll add that and I'll email it to Commissioner Espinoza. Thank you.
Should we take a quick 10-minute break then? I'm waiting for that and we can just take
I was
a break.
going to ask. That would be helpful. Thank you.
That would be well received by me as well.
All right, let's come back. Let's do 9 minutes. So let's come back at 10:05.
We're meeting on the executive meeting, which is the Google.
We
No,
have
we'll
to come back here first.
Okay.
We'll
All
come
right.
back
Perfect.
here first and then go in.
Thank you.
All right, thanks. All right, it's 10:05. Okay, so we are going to go into executive session.
So
This is-
Michelle, can I real quick? I went back and looked at that application on matter L, and it does say damage deposit. So I don't know if we need to discuss that or not in executive session.
I would, yeah, I think I would still like some clarification.
All right.
Yeah. This is Commission Chair Michelle Espinoza. This is a Colorado Real Estate Commission meeting on August 6th, 2024, and the time is now 10:06 a.m. I move that the commission enter into executive session pursuant to Colorado Revised Statute Section 24-6-402 3A2 for the following purpose: to confer with counsel to receive legal advice on specific legal questions regarding complaint number 2024-554JM. Specifically, the commission would like advice from counsel regarding legal basis for proposed discipline and clarification regarding the fees charged, as well as legal basis for responding to application regarding the applications presented in complaint number 2024-999NJ and complaint number 2024-873DA. Is there a second?
It's my mistake. It wasn't B that I had a question on. It was D as in dog. Sorry, not B as in boy. If we could talk about D as in dog.
Okay, so then complaint number 2024-908TS. Do we have, go ahead.
Second.
Thank you, Erica. All those in favor?
Aye.
Aye. Any opposed? 4 votes in favor of executive session. We will now enter into executive session. Please mute your video or shut off your video and mute your audio. right, it looks like we have everybody back. But to let somebody at the division know, I don't know if it's just my side, but it looks like the screen you are sharing is skewed a little bit. All right. Just for clarification, for the public, when we were in executive session, the complaint numbers that we were going over were actually incorrect. The correct applications that we were reviewing was matter B 2024-873DA and matter D as in dog 2024-908TS. So for clarification on that, we're going to go back to matter, I believe it was L, complaint number 2024-554. Do we have any discussion regarding this case?
Okay, so this case is very concerning. It looks like there's a deceptive practice going on. There's predatory language going on. We're not liking how things are, how the tenants are being treated. We would hope that the respondent would return the $34.95 because it should be returning to the client, and we're going to give the division authorization to accept reasonable restitution and to adjust part of the settlement by the restitution amount. So we're giving division authority to work on that, but we do believe, we hope that the respondent would return the money to the client and change the practice that's going on now with the holding the properties for the dollar amounts. Other than that, I would recommend that we approve what staff recommendation was for matter L.
All right. Do we have a second?
Second.
Thank you, Erica. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes. All right, I believe we are now on to licensing matters.
Licensing matter A is complaint number 2024-999. On May 19th of 2008, the respondent pled guilty to a charge of felony fraud by check, $1,000 more, and misdemeanor forgery 2. The applicant was sentenced to a 3-year deferment and 3 years of probation, which was revoked with resentencing on April 4th of 2011 and completed on June 19th of 2013. The deferred judgment and sentence included 3 years of supervised probation, 150 hours of community service, and court costs and fees in the amount of $3,591, which has been paid in full. And we do not have a recommendation, and Investigator Geske can help answer any questions.
Great, thank you. Any discussion or questions?
This issue wasn't disclosed to the commission. Is that correct? For the licensing?
Let me double check.
I thought there was multiple times that it was failed to report.
It was not disclosed on the application.
Yeah. So for that reason, I would vote a negative on this license because it wasn't disclosed.
All right, that's the basis of just that it wasn't disclosed.
Yes.
Do we have any other comments or questions?
Just for my own purpose, is there a time limit or a time frame in which somebody must disclose?
Well, it wasn't disclosed on the application.
I understand, but based off of her written explanation, the event took place over 10 years ago. So I was just curious if there was like a term limit or.
I don't think so.
Okay.
No,
On that.
go ahead.
Oh, sorry, Autumn. I've seen in the past too, where when you, to your point of a time limit, where they're saying they thought that they had passed a certain amount of time and it had been expunged, and how, I'm curious how that comes into play. Are we still requiring them at that point to disclose that, even though it may have been removed or past a certain time period? I would assume you still have to put that on there, but I don't know.
If we get proof that something's been expunged, then it wouldn't be something that they would have to report to you.
Okay. And this was not the case in this one, but that was a clarifying question I needed. Thank you.
But I guess my question would be, yes, they didn't disclose, so that is a problem. The applicant did explain that, but is that enough reason to deny? This happened quite a long time ago. I think as a commission, we have to review, do we feel like behavior, if this person has been rehabilitated? Because if we're going to deny, I don't think denying basis of you just didn't put on your application, I don't know if that's good enough. We have to prove or explain that we did not feel that they had been perhaps rehabilitated or that they were not capable of holding a license. So I think that's a discussion, if we're going to deny, we need to have.
And if I might interject with the commission, because I think Commissioner Espinoza, you're reciting the employment rights criteria when someone reports a crime, whether or not you want to assess if they've been rehabilitated. And I can read those to you if you want to have that factor into your discussion. But before I go ahead and read them, I think that Renee was pointing out Exhibit 1, which was the application. Questions 26 through 29 specifically ask for someone to provide information about prior convictions, and she did not disclose that appropriately. I understand the investigator followed up asking her for a statement as to why, which was Exhibit 4, and the commission should review that statement of explanation and see if it should be given any weight based on the explanation, in addition to the rehabilitation factors that the commission is required to consider by law when someone discloses or they learn of a criminal conviction. And the things that you should be looking at to determine whether or not they've been rehabilitated is the nature of the conviction, whether there is a direct relationship between the conviction and the duties and the responsibilities of the broker, the bearing, if any, of the conviction and what it might have on the applicant's fitness or ability to perform any duties or responsibilities as a broker, any information produced by the applicant or produced on their behalf regarding the rehabilitation and good conduct, and also the time that has elapsed since the conviction. And the commission consider all of those things in assessing whether or not this applicant has been rehabilitated from the criminal conviction and does qualify for licensure now, also considering the fact that it wasn't included on the application. And if there's any questions, I'm happy to answer. Sorry for taking up so much of your time.
No, I appreciate that, Gina. And it only sticks in my head because I know in past, when we've denied, we've had to meet that criteria, and we've got new commissioners. So I just want to make sure they understand the basis on how we're supposed to be either approving or denying an applicant in this situation.
Absolutely.
I appreciate that. Thank you very much. And so as we are looking at that, this was 16 years, if I'm correct on that, with no incident. We do have the 3 years of supervised probation, 150 hours of community service finished, and all of the fees have been paid in full. As to those questions.
Autumn, do you have any thoughts regarding approval
Just
or denial?
refreshing my memory on the employee broker letter. I mean, I don't know. I think could have been an honest mistake to leave that off.
Well, I think the applicant explained that they had done a background check on a previous event not too long ago, and that was their reasoning, is that they thought it was no longer on their history. But I think to Erica's point, it's been a long time. They haven't had any other issues. They've done everything that they were required to do. So I think that's kind of what we need to look at, whether or not they are a good fit for a license.
Renee, I'll just read, it was very short, but she did address this specifically. I did not notify the commission of this offense because I was fully under the impression that because it was over 10 years old since being discharged by the courts, it was not applicable. I fully take responsibility for the fact that I did not adhere to the application rules and failed to notify the commission. I've learned my lesson. So I
Okay, I could go either way on this one. So that's fine. I had some issues with, it looked like there were some issues previously, but that was quite a while ago where things weren't done, but it looks like things are done now. So I'm okay with it.
All right, so can we get a motion?
Motion to approve licensing matter A.
second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes for full approval.
All right. So ready for licensing matter B?
Yes.
Okay, just making sure. That is complaint number 2024-873. It is an application. On June 13th, 2022, the applicant was convicted of theft of $1,000 to $2,000, class 1 misdemeanor, and theft of $20,000 to $100,000, a class 4 felony. The felony was dismissed in March of 2024 after completing probation. The applicant was sentenced to 2 years probation and restitution in the amount of $141,627.13. The probation is terminated and the restitution has been paid in full. The victim stated that after the applicant was at his home, his wallet was stolen. The applicant used the stolen credit cards and also transferred $125,000 out of the victim's investment account. The applicant's division of insurance license was approved with restrictions, and the applicant's Colorado real estate license application was previously denied in 2023. There is a recommendation for denial, and Investigator Quintana is here to answer any questions you may have.
All right, any discussion?
I thought there was still money owed. It says that money is paid, but I thought there was still money owing. To the victim. I thought there was still quite a bit owing.
Tabitha?
I'm looking at this. Hold on one moment.
It's Exhibit 2.
All right.
Yeah, it says, let's see. It says that right there is a zero balance.
Zero balance to the victim or to the court?
There, the applicant has paid everything. There's no money that they owe.
Restitution and fines are put into the court and then they distribute it.
Okay. No. The problem on this one is that they weren't honest and truthful on the application to start with. And that's why it was denied previously.
Well, that and this is a very new case. I mean, this is in 2022. That this person was convicted. So there is a lot. We previously, I believe, denied this case. I don't think anything has changed since we reviewed this case previously.
It'd be hard to say it's the person's rehabilitated.
Right. I mean, we appreciate the fact that this person has made the restitution, and that's great, but the nature of this was so big that I personally don't think that we should be granting another application. I don't think rehabilitation has happened. I see, appreciate again the progress, the restitution being paid. However, and not enough time has passed, in my opinion.
I would agree.
Autumn, Erica, do you have any thoughts or?
I would agree with that. I think it's just too close to, in real estate, we have so much access to people's financial documentation, and I just think that this would be inappropriate at this point to have licensing in this industry right now.
Okay, so in licensing matter B, we're going to recommend denial.
Okay, we have a second?
Second.
I think I heard Erica first. Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? Motion passes for denial.
All right. Matter C is a preliminary advisory opinion. Complaint number 2024-1172. On February 10th, 2017, the applicant was convicted of child abuse with knowing and reckless cause, a class 3 felony. The applicant was sentenced to 18 years in prison, court costs, and restitution in the amount of $13,857.50. The applicant still owes $6,358.80, and the applicant is currently on parole through 2028. There is no recommendation, and Investigator Quintana is here to answer any questions.
So it looks like the applicant did multiple positive things in prison. So I give the applicant lots of kudos for that. That looks, that looks great. The fact that parole is still ongoing, we would not give a positive opinion if someone is still on parole, correct?
Historically, we have not, since I've been sitting on the commission. I think that I agree. Great things, this person is doing great things of making themselves better. But at this time, I think it's too early to really give a positive opinion, especially with parole for another 4 years.
Right. So I would recommend a negative opinion, and then suggest that continue doing good things, improving the life, and if they're still interested, to come back in 4 years after parole is done.
All right. Do we have a second?
Second.
Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes for negative opinion.
Matter D is an application. It's complaint number 2024-908. On December 19th, 2012, the applicant was issued a cease and desist order by the Nebraska Real Estate Commission. The order was based on a Nebraska investigation that showed the applicant had listed 2 Nebraska properties in a Florida MLS. The Florida MLS shared that information with Realtor.com. As a result of the Nebraska cease and desist, the Illinois Department of Financial and Professional Regulation took action on the applicant's Illinois real estate broker license. The applicant was issued a consent order on February 25th, 2014. The state of Nebraska reports no disciplinary action. The applicant is licensed and active in 33 states, inactive in 4 states, and holds an Ohio law license in good standing. There is no recommendation, and Investigator Levy is here to answer any questions.
All right, any discussion?
I didn't see any reason not to based on the dates and what had taken place. So I would move forward with a positive opinion.
It's actually an application, so it would be an
application. Thank you very much.
Okay, so is that a motion for
Approval?
approval? Erica?
Yes, it is. Thank you.
Do we have a second?
I'll second.
Okay, any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes for full approval.
Licensing matter E is an application. It's complaint number 2024-995. On January 8th, 1999, the applicant was convicted of felony theft. The applicant was sentenced to 10 years probation and ordered to pay restitution in the amount of $134,962.12. The applicant has a $200 monthly payment plan with a current balance of $83,112.12. Applicant has completed probation successfully and the case is closed. There's no recommendation, and Investigator Quintana is here to answer any questions.
The concern on this one would be that the applicant didn't notify us about the conviction and that there is still a large balance owing from this conviction.
I agree. With that kind of balance, that's a bit concerning in real estate when you have access to different things. Typically with that kind of balance, I don't believe we have approved applications. Anybody else have any opinion, comment?
Well, and it was specifically tied to crime within real estate. So I felt like that was a huge problem, in my opinion, coming back into the industry.
Okay, so I would motion for a denial on E.
Wait, do we have a second?
Second.
Any further discussion?
Commissioners, can you just give me, once you voted, the grounds for denial, whether it's lack of rehabilitation, lack of truthfulness, honesty, and good moral character, just because we have to track that.
Yes, all those things.
all those things. And I will say her personal statement didn't address the crime, in my opinion.
Okay.
It looked like we may have been missing a page on the explanation letter, honestly. But yes, there were quite a few holes in it. So
All right, so we have a first and a second. May I get all those in favor? Any opposed? Motion passes for denial of licensure.
Licensing matter F is an application. It's complaint number 2024-950. On November 19th, 2012, the applicant was convicted of marijuana concentrate possession with intent under 1 pound, a class 5 felony. The applicant has completed probation successfully and has paid restitution and the fine in full. Case is closed. On May 3rd, 2024, the applicant pleaded guilty to a class 2 misdemeanor child abuse, knowing reckless with no injury. The applicant was sentenced to 12 months deferred sentence and a fine of $798.50. The applicant is still on deferment and the fine has been paid in full. The applicant did not disclose this conviction on his application. Additionally, the applicant was principal to a transaction that resulted in a license downgrade and stipulation for a Colorado State real estate licensee. The recommendation for this is a denial, and either I or Investigator Quintana are here to answer any questions.
All right, any discussion?
I would motion that we approve the denial on this application. It sounds odd. We approve the denial, but we issue a denial on this application.
All right, do we have a second?
And again, if you can just give me an indication about the grounds for denial.
I would say there's still a lack of rehabilitation, and we've had lots of prior issues. It's not a one-time thing.
All right, did we have a second on that?
I am, this is dropped off. Sorry, I logged out. 1 second, I'm trying to get this back in front of me.
And if I may to remind you, because we are, if you are going towards a denial, then we have to, on the record, discuss 24-5-101-4, those provisions. Would you like me to read those to you?
Yes.
I'm just, sorry, go ahead, please.
So it's the nature of the conviction, direct relationship between the conviction and duties, if the bearing, if any, the conviction may have on the applicant's fitness or ability to perform such duties and responsibilities, any information produced by the applicant or produced on his behalf regarding rehabilitation and good conduct, and the time that has lapsed since the conviction.
Just for my own purposes, it looks like there still is an outstanding balance.
No, there's not an outstanding balance.
Exhibit 2 shows a balance. I don't know if I'm missing that somewhere else.
Let me take a look here.
Let me pull up the exhibit.
This one also has issues with a prior contract and the company. and the people involved as far as who was going to be employing broker for who, because someone was downgraded, and there were multiple issues with that in this case. You can't be an employing broker for somebody if you've been downgraded.
So just to confirm, there is no balance. The way that the exhibit is, it's confusing. But the last column, outstanding balance, is at 0.
Yeah, thank you.
Sure.
But I do understand he's still sitting out the deferred sentence. He's still in a deferral period. Is that accurate, Sarah?
That's accurate, yes.
Okay.
So if he's still deferred, is it probation or is it just deferred? Is it?
It's considered a deferred sentence, but it is somewhat of a quasi probationary period, because the idea being that, okay, if you don't do anything during this period, you know, at the end of the period, a wait and see period. And he's I think only 2 months have elapsed since he's been convicted.
Okay, well, that's another reason that if we're that close to a conviction and there's still a deferred sentence, we wouldn't normally approve someone for a license till that period was over.
So that would fall under the time, right? The time for rehabilitation.
Correct.
Is not there. So, does someone want to make a motion?
I motion for denial on application F.
I'll second.
Thank you. Any further discussion? All those in favor?
Aye.
Aye.
Aye. Any opposed? Motion passes for denial. I believe we are now on to ESP matters.
Yes, sorry to have to keep bringing these to you. The first one is regarding complaint number 2024-415. This individual signed a stipulation back in May, agreed to pay a fine and to take coursework. I apologize, for some reason the violations aren't listed there, but this was in relation to a continuing education audit. They signed the agreement and then they have not complied with the terms. And so our recommendation would be to proceed with a violation of 12-10-217-1M, seeking $2,500 in fine, a final agency order, public censure, and of course the requirement that they comply with the terms. They are currently inactive, so we're not asking for the suspension until they comply because they're currently inactive. But if you wanted to include that something like that, you certainly can.
And they're inactive due to them not renewing, or, you
Yes,
know?
It is, yes, that is my understanding, but let me pull up and just double check. Sorry, too many screens open.
And I don't remember, how long can someone remain inactive before they would have to start all over basically and take the test, requalify? Is there a time limit there?
So you can remain inactive, I believe, indefinitely. I think what you're referring to is if somebody expires. So you renew your license every 3 years. If you don't renew your license, you do have an automatic right to renewal within 3 years, or you have to start over. But you can renew your license on an inactive status, but it's the renewal that you have to stay on top of. Let me just pull him up real quick. And
so you still have to renew every 3 years and just say you're inactive.
Correct. If that's what you were choosing to do. So I'm sorry, it does look like he went inactive due to an insurance audit. So they were put on an inactive status for failure to maintaining E&O insurance while they were active. So it appears as though it's somebody that's not overly interested in their license at this point. Let their E&O insurance lapse. They would have been notified that they went inactive. They're not responding to our attempts. And this is in their stipulation for diversion that they signed. They agreed that if they violate that the next step would be formal disciplinary action, which is what we're seeking now.
And they have an ER license. So is there anybody underneath them?
No, they're currently inactive.
Okay, well, I'd recommend that we accept the recommendation that we were given of the fine of $2,500 at FAO and public censure.
We have a second?
Second.
You. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
Okay, the next matter is involving complaint number 2023-1525. And this individual signed a stipulation in March, also for a continuing education violation. And they did pay the fine, but they have not taken their coursework. They are currently active, and I believe we've made attempts to contact them directly and through their employing broker, and have been unsuccessful. So we are recommending a violation of 1210-217-1M, which is violation of a lawful order, seeking $2,500 in fine, final agency order, public censure, and a requirement that they comply with the current education requirement under the previous stipulation. Now in this one, and forgive me, one other thing, I'm sorry. And requesting that there is a suspension until compliant because they are currently active.
I was going to ask, how are they still active?
Because we don't have the automatic right to, we wouldn't summarily suspend somebody under this circumstance. But I think that moving forward, that's the appropriate sanction to ask for.
And the employing broker has removed them from their office.
Yep. Yeah.
And I don't know, let me see if they've gone to somebody else, because when I last checked, they were still active, which is why we were seeking the suspension. But let me check. I did not check this morning. They are in fact inactive at this point. I'm sorry, that happened at the end of June.
So being that they're inactive, once this goes into place, will this go into place without them signing it though?
No. What the normal procedure is, if you agreed with the recommendation, I would send them out a new stipulation with those terms. If they don't respond to me, then it's referred to the Attorney General's office and they would litigate the case through the normal processes. Oftentimes with folks that are not participating, it ends up in a default judgment, but that's sort of the normal procedure that we'll go through.
Do we still need to do the suspension?
Probably not, given that they're inactive. We do put a notice on their license so that if they were to be activating right now while we're having this conversation, I would get notified. So then I would continue to try to communicate with them to resolve this.
But they could be active.
They can't activate at any time.
So that's why suspension might be beneficial. If we do suspension, then they can't just all of a sudden be active, correct?
Correct.
But if they, on a suspension though, if they don't sign this, the suspension still doesn't go into effect.
Until it, again,
until it goes through that process.
Correct.
Yeah. So I think, Renee, you and I are on the same thought process, just two different trains. We can recommend a suspension, but until they sign it, they could still go active, because the suspension wouldn't go into place until till it went down the legal path or they signed it. So what we can hope for now, Penny, correct me if I'm wrong, is you put the notice on their license so that you're notified if they go back, try to activate their license, correct?
Correct.
So I don't think a suspension would really matter because it doesn't go in effect today. Does that make sense, Renee? That was my question too. I was like, well,
yeah.
So I don't think we need to ask for it since they're inactive.
Okay, so then we'll just go ahead and motion to approve recommendation for ESP matter B.
We have a second?
I'll second.
Okay. Thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
And the last one is involving case number 2022-2011. And this one also involves a continuing education audit. However, this one, the individual did not respond. It did get litigated. We did get a final agency order, I believe on a default judgment, requiring the fine and the coursework, and they have not responded to this. And so the recommendation is to proceed with a violation of 1210-217-1M, seeking the $2,500 and fine, a final agency order, public censure, and revocation of the license, because we're at the final stages of the process here that we go through with each one of these.
Okay, I had to say motion to approve recommendation for ESP matter C.
Second. Great, thank you. Any further discussion? All those in favor?
Aye.
Aye. Any opposed? Motion passes.
And that is all I have for you. Thank you.
All right, friends, looks like we are at the end of our August 6th, 2024 commission meeting. Thank you everybody for your participation and all of your hard work, division staff. We will see everybody in October. Have a great day.
All right, bye.
Thanks, commissioners.